Judge Langholz. We will now be ready to hear the case of Shimp versus Gibbons. It's number 23-2025. For the appellants, the Shimps, we have Ryan Koopmans. And for the defendants, we have Mr. Paul Esker and Mr. John Maschman, who you understand you'll be splitting time. So we'll leave it up to you to watch the clock on that. So, Mr. Koopmans, whenever you're ready.
Thank you, Chief Judge Tabor. May it please the court. Before I get started in the argument, I just want to say I too, as a lawyer, enjoy getting out of Des Moines. You learn something every day. You learn something when you travel. Can you hear me? All right?
Yeah.
I'll keep talking. We'll see if it reverberates back. Better? Worse?
It is better.
All right. So when I pulled up, I'm going to start off with the story. So this is for the kids, not for you so much, so you can listen and maybe we'll adjust as we go along. So when I pulled up this morning, a little before 8 o'clock, Bon Jovi was blasting over a very loud speaker as the principal met every student. I had never seen this before. It was very exciting. Living on a Prayer was what was playing. I had never had that when I was a kid. Maybe I'd be more excited to go to school if I had. But now my suggestion for you, not just for the children, for the kids, is that perhaps when we come to oral argument in Des Moines, you can blast Bon Jovi or something else, and then litigants and lawyers will feel more excited to come in. So there it is. All right, now that the sound is good and we have the warm-up story ready to go, thank you, Your Honor, I appreciate it. We're here today because in 2018, Ellie Shimp was on Clear Lake here and was in a jet ski accident. She was injured, she hurt her leg, she went to the Mercy Hospital in Mason City. She had a broken tibia, but she also had a serious injury to her popliteal artery, which is an artery that brings blood flow down to the leg. Without that blood flow, your leg dies, your tissue dies. The doctors at Mercy missed that. They didn't know that had happened. They should have diagnosed it. They should have treated that. They didn't, not for over a day and a half. At that point, when they finally found her, she was transferred to Mayo, where they did operate, they did save the leg, but she has permanent and long-lasting injury for that. Because of that medical malpractice, Ellie brought a lawsuit against the physicians and Mercy in Mason City. In that case, she has to prove that one, the doctors there committed malpractice, that their treatment fell below the standard of care, and two, that caused her damage. So if they would have done their job right, her leg would be much better off today. Instead, because they missed the diagnosis, she has permanent injuries. If Ellie doesn't prove that at trial, if the jury says, no, what happened to you, even if the doctors would have done everything they could, your leg would still be the same, then those defendants win. But if she proves that proper treatment would have made her leg much better off, then she's damaged, then she has a claim against the doctors. The doctors say in that case that even if they did something wrong and they caused her damage, that the jury should compare the fault of the driver of the other jet ski who hit her under the Comparative Fault Act statute, Chapter 668.
Could I ask you about Chapter 668?
Absolutely.
So, would you agree that it allows a comparison of all kinds of fault? Fault of the jet skier and med mal fault of doctors?
It allows fault on the same claim. And under Iowa law, the common law, how it treats the original tortfeasor and how it treats the med mal, those are two separate claims. So inside of each of those claims, Chapter 668 would apply. So let's say Ellie was partially at fault in the accident. Then Chapter 668 would compare her fault, the jet ski driver's fault. But in neither of those two claims do you ever compare the fault of the original tortfeasor with the fault of the doctors.
I'm interested in your characterization of these are separate claims because it's actually a claim for damages with separate theories, right? Or because a claim for certain injuries, right? And those injuries are basically the same that we're talking about, right? The injury to her leg.
So they're separate, and let me just separate the damages for a second, because in the second case, in the medical malpractice case, there are no damages for her broken leg, for example. Doctors aren't at fault, they properly treated her broken leg. There aren't any damages in that med mal case for the pain she felt while laying in the water, like excruciating pain. When she came to the hospital, she was on a 9 out of a 10 scale. Those damages aren't involved in the second case. In the second case, it's all about the permanent injury to her leg because of the loss of blood flow. Now, the original tortfeasor is also responsible for those damages under the original tortfeasor theory. But the key point and why 668 does not apply here is why that original tortfeasor is responsible. In Hunt versus Erzin, the Iowa Supreme Court said that that fault or that responsibility of the original tortfeasor is essentially vicarious liability. It's derivative. So when you have two parties one who's derivatively responsible and one who's primarily at fault, 668 treats them as a single party. Their fault is not compared. That's what Justice Waterman held in Jones versus Glenwood, which is cited in Mercy's brief, and what the Iowa Supreme Court held before that in Biddle versus Centauri Memorial Hospital. So that's why you have these separate claims, and that's why, even though the original tortfeasor is responsible for the second claim too, you do not compare the fault between the two.
What if no, go ahead.
Counsel, what do we do with the restatement third provisions that Mercy cites in their brief? Because those seem to support their position.
Those restatement provisions mainly just say they just reinforce the original tortfeasor rule. And let me tell you why their argument doesn't work, because their argument would actually destroy the original tortfeasor rule. If they have their way, we try all of this together, where you have the original tortfeasor in the courtroom, you have the medical defendants in the courtroom. And under current Iowa Supreme Court precedent, the original tortfeasor cannot even introduce evidence of the medical malpractice because they are vicariously liable for it. They cannot reduce their liability at all. They can seek indemnity against, and that's what Hunt says, they can seek indemnity against the medical defendants in another case, but they can't reduce their liability. So let's use this example. Let's say everything is tried together, and the jury comes back and they say the original tortfeasor is 10% at fault, but because when we decide that the medical defendants are 90% at fault, that means that the original tortfeasor is only responsible for 10% of her total damages, and it is not responsible for the medical malpractice because 668 destroys joint and several liability. So really, what they're asking for is for you to overrule Iowa Supreme Court precedent that lets that original tortfeasor off the hook, and that cannot be the case. Go ahead.
I was just going to ask, do you concede that the restatement third, section 35 has been accepted by our Iowa Supreme Court?
I don't know if it's been accepted. They continue to follow the original tortfeasor rule, and they continue.
It's referred to in Asher versus OB-GYN specialist, so that's why I wondered if you would concede that.
I concede it only to the extent that the original tortfeasor rule still applies, and it absolutely does. And so again, they're asking you to overrule the original tortfeasor rule. And in the published case, let's see. Well, anyway, and the Iowa Supreme Court said in Ishland versus Wolf Clinic, again, after 668 was enacted, that the original tortfeasor cannot introduce evidence at trial of the medical malpractice because it doesn't matter. They're vicariously responsible for it. If you compare fault, then all of a sudden they can introduce that evidence, and the original tortfeasor can actually get out of their responsibility vis-a-vis plaintiff. The second point, of course,
Medical, we had everybody in the room, so we had the original tortfeasor Jets here, the medical malpractice defendant, and the plaintiff were all in one happy suit, right? Given the fact that there are different events that lead to the damages, so you've got the jet ski accident damages that the doctors aren't responsible for unquestionably, and then you've got the claim fault of the doctors for a different set of damages. How do we even compare fault between those two things when we have the verdict form? Do they have to break that out in a damage interrogatory? How do you sort that mess out?
Well, and that's exactly what I was going to next, and that's the DeMoss problem. I mean, you just cannot. And so number one, you can't because the original tortfeasor's responsibility for the malpractice is vicarious. And so as Justice Waterman held in Jones, that is not applied. 668 does not apply. You don't compare the fault between a vicarious liable person and the primary person. Second is in DeMoss, the court said that you do not compare the patient's fault to a medical malpractice case. But you don't treat patients any differently normally under 668 than you do other third parties. And the problem is, if you have everyone in the same case, then in cases where it is alleged that for the original accident that the plaintiff is also partially at fault, what do you do with that fault compared to the medical malpractice defendants? Because the law says you cannot compare the fault of the plaintiff with medical malpractice. So the entire thing, unless the Irish Supreme Court were to overrule the Moss, this entire thing breaks down and absolutely does not work.
But even if we didn't have anybody claiming that the plaintiff was at fault, and I understand here in the jet ski collision, there was some claim of fault by the plaintiff, but let's say you take that out of the equation and just say, everybody concedes plaintiff wasn't at fault. Even between the two defendants, the medical malpractice defendant and the jet ski defendant, how do you split out the damages given, how would that work in terms of the jury instructions and the verdict forms and what have you? How do you sort that out given that you got different types of damages?
And I think you're coming at what I was arguing earlier from a better way, so thank you for reframing it. So you just cannot. Because under current Iowa Supreme Court precedent, the original tortfeasor is responsible for 100% of the entire damages, even the medical malpractice. So the problem is that in this case, and maybe this is why it's just so strange, the reason why the original tortfeasor is responsible for the medical malpractice is a legal effect. Is not a, and you can maybe say it's proximate cause as well, but also the Supreme Court said it's a legal effect, not a factual effect. And so they're responsible, just like if you give your car to your daughter, she drives it, your daughter gets in an accident, you are vicariously liable for that accident. You're not primarily responsible. So the jury would never compare your fault as the owner of the car with your daughter's fault as the driver of the car, unless there's some separate claim about you had not maintained the car or something like that. That's the exact same case that we have here, and that's Hunt. And then the Irish Supreme Court reaffirmed Hunt in State versus Philip Morris in 1998, saying that the original tortfeasor's responsibility for medical malpractice is a classic vicarious liability issue.
Thank you.
If you look, we cited a New Mexico federal court case in our brief, and that case cites two cases from the New Mexico Supreme Court, Lujan and Lewis. And both of those cases do a very good job, I think, of laying all of this out. And the interesting thing is that Lujan actually relies on the Iowa Supreme Court's decision in Hunt, that the reason that the original tortfeasor is responsible is vicarious liability, not primary liability. And so those lay out that you have these two separate divisible claims. You have the claim for all the injuries that if there would have been proper treatment, those are against the original tortfeasor only. You have the second claim for all the injuries that happened because of the medical malpractice. And both the original tortfeasor and the doctors are liable for that. But you cannot compare the fault because that's an indemnity vicarious liability issue.
What about the theme that they'll recover double damages or, that?
So when 668 does not apply, which it doesn't in this case, the pro counsel set-off rule still applies. So you have the amount of the settlement is not on the record, so let me just give you a hypothetical. Let's assume that the settlement with the settlement with the jet ski driver is $1 million, and that the injuries, that also significant injuries, the broken tibia, all the pain, everything that happened after that. Let's assume that that was worth $800,000. Then so $200,000 of that was for the medical malpractice. Then there's whatever recovery there would be against the medical defendants, they could offset that $200,000. So the pro contra setup rule still applies. You still do not get double recovery. Of course, it may be that the entire settlement only covered that first claim, those injuries that would have occurred even if all the treatment would have been perfect.
Would that swing then on how much you got into the weeds in the settlement? Because typically in the settlement, you don't break it down that way, right? You just say, hey, we'll take $1 million, and they say, we'll pay $1 million, you're good to go. You don't break it down 800 and 200, or hey, I guess if you're being strategic about it, you might say it's $1 million and it's just for the damage from the collision. It has nothing to do with the misdiagnosis and the problem with the leg. To kind of try to stop that recovery back against the original tortfeasor.
Right, that would be the defendant's burden to prove that the damages, the medical defendant's burden to prove that the settlement amount could not possibly be just for the claim, the damage in the first claim, that it had to exceed and run into the medical malpractice settlement.
Is that an issue we need to even resolve in this case?
No, I mean,
it seems like a fight for down the road depending on what happens.
Correct, and everything in this case, this is very much a kind of hypothetical. This is not interlocutory appeal, and this is just a pure question of law based on the complaint and almost nothing more.
Thank you.
You mentioned a few times, sort of the lingering case law in the background, at least arguably we have to overrule to go the other direction. The Supreme Court had a chance to keep this case, to reevaluate its case law. They came to us and said, how much are our hands tied, or is there a bit of daylight between existing case law and these facts?
There's no existing daylight because of DeMoss and because you have to overrule the original tortfeasor rule as well and say that the original tortfeasor might be off the hook because some of the responsibility would be transferred over and it would not be doing several liabilities. So really your hands are, I think, completely tied between those two guideposts.
Can I just push back on that for 1 second? Is that okay? So since DeMoss, we've had the restatement third docket, we've had this John case that your opponents, weigh heavily on, and you have Mulhern where the patient's negligence was compared. So how do we tie that all together?
So DeMoss doesn't say that you can never compare the patient's negligence. It says that if the patient's negligence was an integral part of the treatment, then you can compare it. And in fact, Justice Waterman cited DeMoss affirmatively in Mulhern, so only reaffirming its principles.
Thank you, Counsel. We'll have more time. Mr. Esker.
May it please the court. Counsel. Can everyone hear me okay? My name is Paul Esker. I'm here on behalf of Mercy and the Mercy defendants. Thank you for this opportunity to participate in court on the road in Cerro Gordo County for the first time and in Constitution Day. I'd like to pick up with Judge Greer and Judge Fuller's question where you all left off with my friend on the other side. There is, to be clear, tons of daylight between DeMoss and the case at bar, and I believe Judge Greer is absolutely correct that the intervening case law provides even greater clarity between the distinguishing factors between DeMoss and the case at bar.
I think, as I understand DeMoss, the whole underpinning of the rationale of DeMoss is we don't care how the plaintiff got in this condition. The doctors have to treat the patient non-negligently, right? So it doesn't matter if the plaintiff shot himself in the foot, cut off his own finger. In DeMoss, I think it was smoking, not taking care of himself health-wise, led to a heart attack type of thing. It doesn't matter how the plaintiff got in this condition. Why is the logic of that any different? Why does it matter if the third party caused the plaintiff's condition? The point is, that's the condition you treated.
That's exactly right, Your Honor. I think there are two fundamental principles at issue here. There's a more narrow principle, which DeMoss stands for, and then there's a broader underlying principle that is overarches DeMoss and applies to this case. So the first fundamental principle is that, as you stated, Your Honor, patients are always entitled to non-negligent medical care. It is absolutely true, and that's the proposition of DeMoss. But if we go directly to DeMoss, it is focused specifically on the question of whether that principle or how that principle interacts with a claim or a defense of contributory negligence on the part of the plaintiff specifically. So the second one,
I agree with you that DeMoss only addresses the plaintiff's comparative fault. I'm just questioning, why is the logic any different with the third party's fault?
so the logic is different because of the second fundamental principle, which is from Mulhern, which is one of the cases that Judge Greer cited. It's the Iowa Supreme Court case from 2011, which pointed out that the legislative intent underlying 668 is to make defendants pay in proportion to their fault. That fundamental principle of 668 has to apply to this case, where the question is the comparative fault of a third party and not the contributory negligence of the plaintiff. If the court extends DeMoss in this case and expands the holding of DeMoss to include all third-party negligence, it would subsume 668 and have far-reaching effects for comparative negligence cases or comparative fault cases in all types of fact patterns.
But I think your friend on the other side's argument in response to that is that's what causation is for. You're going to prove up, then we're going to assess liability accordingly. Why isn't that a satisfying answer to your conundrum?
Your Honor, I think that's exactly the right point, and my friend on the other side, what I think they leave out is that that's a question for the jury. The fundamental legislative intent of Chapter 668, what the legislature considered, to be most important in adopting that provision was that a fact finder should be the one making the determination about who's at fault and the proportion of that fault, so that defendants, as Mulhern indicated, only pay in proportion to that fault. What we have here is a
But
request.
how in any way is the jet ski, the tortfeasor jet ski driver's negligence, how do you compare that to the claim? We don't know, obviously, if they can prove their case, but the claim is the doctor misdiagnosed it and made her worse. Where's the you're comparing two different events.
Respectfully, Your Honor, actually, we're not. So I think it's helpful to get into some of the damages claims that I think Judge Greer asked about when my friend on the other side was up here. So there are a couple things that we agree on. So there's the broken leg and the pain and suffering that Ellie tragically endured in the water after she was injured. Those categories of damages are not at issue in the case, and plaintiffs have not claimed those. The issue is the injuries caused by the occlusion to the popliteal artery. The popliteal artery, our experts assert, was injured at the time of the jet ski accident.
And obviously, if the jury finds that the die was cast as soon as she got hit by the jet ski,
Exactly.
it doesn't matter what the doctors did, they lose.
Exactly.
Right? So that doesn't change the fact that I'm not understanding how you're getting to compare fault. That's a causation issue in my head anyway, because you got two different events that you're talking about. You got the jet ski negligence and you got the medical negligence. Two different events. How are we comparing those two on the verdict form?
So, Your Honor, I believe you're partially correct, respectfully. I do believe we have a causation issue, but we also have a comparative fault issue. It is possible that the jury could conclude on causation alone that the medical defendants are not negligent and therefore rule in favor of the defense at trial. But additionally, they could alternatively hold that the injury to the popliteal artery was partially the responsibility of the jet ski violently smashing into Ellie's leg, and partially the responsibility of the medical defendants.
Can I follow up on Judge Alder's question? Just as a practical matter, what do those special interrogatories look like? Because I think in your briefs you say you're not seeking allocation against Ellie for any fault on her part. So how does that work on a comparative fault ballot?
That's correct, Chief Judge Tabor, and I do believe that it's a complicated question. I first admit that I don't believe that these verdict forms and the complications that they present are any more complicated than really any complex comparative fault case that juries and judges and district courts deal with in Iowa every single day. Admittedly, they can get complicated, but in this case, it would be the same as any, let's imagine, a car accident where there's multiple alleged negligent drivers. We would have separate verdict form lines asking the jury to ascribe a percentage of faults to, in broad strokes, 4 categories of alleged tortfeasors. Number 1 is the jet ski owners. Number 2 is the jet ski driver, because the plaintiff sued those 2 separate sets of parties in the initial action. Number 3 is my clients, the hospital defendants. And number 4 is essentially the provider defendants represented by my friend Mr. Maschman. When all 4 of those defendants are listed on the verdict form, then consistent with the fundamental purpose and intent of 668, the fact finder gets to hear all of the complicated evidence, all of the expert testimony, all of the facts testimony, and
The more complicated question in my head when I'm trying to think about doing the jury's, the interrogatories and jury instruction stuff, is you have, and I think in plaintiff's brief, they do a nice job saying, okay, with the tortfeasor, you could compare fault with the plaintiff. With the medical malpractice case, maybe so, maybe not, probably not in this case. So what are we going to do down the road with the next case when maybe everybody's fighting about fault and causation, but you have to compare plaintiff's fault?
Absolutely, Judge Greer. So this presents a common quandary, which is what happens when contributory negligence is a defense to some of the alleged tortfeasors, but not for others. To be candid, I believe it's a red herring, because in this case, it's not apparent that the plaintiffs intend to stand up at trial and argue that they themselves were negligent to the jury. But I will go down the road gladly, Your Honor. So I believe that one way you can solve the problem is by doing the 4 comparative fault lines that I suggested, and then having a subsequent question that says within the 2 line, or if you ascribe any faults to the jet ski driver and or the jet ski operator or owners, then within that portion of fault, do you assign any contributory negligence to the plaintiff? So that it's clear that it's sort of a subset of those 2 lines of comparative fault on the verdict form. Is it complicated? Yes. But can a jury handle it? Absolutely. They do it every day. And I believe that if the court reverses the district court on that basis, it has concerning consequences for what district courts are to do later on down the road, because as I indicated, this is not a situation that presents itself only in the medical negligence context. And I believe that what plaintiffs have done here is attempted to expand DeMoss beyond the medical negligence context and beyond the plaintiff negligence context, which is the very narrow circumstance in which DeMoss lives.
Give us another example if you're worried about us unleashing this parade of horribles on our citizens. What's another example where this could come up?
Absolutely, Your Honor. So imagine more standard comparative fault fact pattern of a car accident. So let's say you have a driver who's driving drunk and so allegedly negligent. They are hit by another driver who is also allegedly negligent. Then they are transported in an ambulance, and that ambulance is hit by another driver that is allegedly negligent. I know it sounds a little bit like a torts class hypo, but if you have all 3 of those alleged pieces of negligence, you have the same circumstance that's presented here. The contributory negligence of the driver is a potential defense to the first accident, but not a potential defense to the second accident because they were not driving the ambulance that was hit by the third driver. So there's all kinds of situations outside the medical negligence context where you have to deal with this interplay between contributory negligence and comparative fault. And frankly, that's something that the district court will have to work out based on the specific facts of the case. I know my time.
Do you agree? I just want to.
No, I apologize.
Yeah, no, I understand you're splitting time. Do you agree that this issue about what we do about pro tanto and recovery back, that's not an issue we need to solve here today? Is it? Is that a fight for a future day?
Even more simpler, Your Honor. I think that issue has been resolved by the Thomas case. As we know, as my friend Mr. Maschman noted in his brief on page 17, the Thomas case held that 668 replaced the pro tanto credit rule. But at a minimum, you're absolutely right that we can deal with that in another day. I'd also, before ceding to my friend, I'd like to briefly note that we believe that the others, at a minimum, if this court is to reverse, they should not issue a definitive ruling as to whether the comparative fault, stating that the comparative fault act does not apply in this case, because that relief has not been requested by the other side. They have not filed a motion to strike the comparative fault defense. So at a bare minimum, the court should reverse and hold that.
Well, doesn't that just throw us right back into the same, pond we're trying to swim our way out of? I mean, if we say, yeah, it's reversed, you shouldn't have done this, send it back with no direction, and then you get to make the argument again, and hopefully you can get the district court to do the same thing that brought us here in the first place?
But 2 responses to that, Your Honor. First of all, my argument stems from fundamental principles of waiver and error preservation. The plaintiff has not raised that issue at any point with the district court, has not filed a motion to strike the comparative fault defense, has not sought to definitively resolve that issue for purposes of this case. My second response is that any comparative fault instruction, because it's a part of the verdict form, is going to be subject to how the evidence comes in. And the district court retains the jurisdiction based on how the evidence comes in to make a final determination about what's appropriate.
Thank you.
Yeah.
I did. I still haven't heard a full response to plaintiff's argument that DeMoss can't be distinguished on the basis that it involved the plaintiff's fault, because the Comparative Fault Act treats plaintiffs the same as third-party defendants, and released parties. So how do we get around the language of the Act?
Yes, Your Honor, I believe that's a very important issue. 2 responses. First, if you look at the language of DeMoss, I'd point out that the court in DeMoss specifically stated, at issue in this case, at issue are questions concerning when, if ever, a patient's fault may be considered by the jury. So they very specifically cabined the holding of DeMoss to a patient's fault only. They again discussed the same issue on page 305 of the reporter of that case. Second response is, I think that the court should absolutely anchor this decision in the text of 668. And my friends on the other side have not identified any authority for the proposition that 668's definition of liable, which is the operative word here, whether the jet ski driver or jet ski operator is, quote, liable for the same damages, i.e. the damages to Appellees' popliteal artery. My friends on the other side have not articulated any reason why that word liable should not be applied to the third-party tortfeasors here. The only thing they point to is DeMoss, which is specific to patient's liability, and I think it's very important to emphasize that that case is an outgrowth of the eggshell plaintiff rule and the fundamental proposition that plaintiffs should not be held liable for a negligence that puts them into an operating room.
Were you in charge of talking about section 35, or were you here over here?
Because we have very little time left, I'll leave it to my friend. Thank you, Your Honor.
So I want to hear about it.
You always get cheated if you're the second arguer, Mr. Maschman.
Hello, John Maschman. I'll just open the floor to any questions you have since I have 40 seconds left. My purpose here was really to argue that we're not arguing for the overruling of DeMoss and that it's the facts are distinguishable. However, I'll open the floor to whatever the judges want to talk about.
Well, I am curious about, do you think restatement third, section 35, how does that help you here?
Well, I think that my co-counsel addressed it, but as you've noted, I believe that the Supreme Court has tacitly adopted it, and it essentially stands for the proposition that successive tortfeasors here should be compared under 668, and we believe that the straightforward application of the statute compels this result, and that I see that I'm out of time. May I conclude my answer? That the parade of horribles enunciated by the appellants are somewhat of a red herring, and that, as my co-counsel noted, juries have to deal with these types of matters every day, and we trust them to sit through the issues. So. If there are no more questions, I will simply stand on my co-counsel's argument.
I think we might have a couple more questions for you.
Sure.
Just
Just one more question,
Yes.
Counsel. Can you respond to opposing counsel's argument that the original tortfeasor rule involves vicarious liability, and so if we consider the original tortfeasor's fault here, we would be going against cases that say you can't do that in vicarious liability situations?
Right. Not to overuse the phrase red herring, but I think that argument sort of it takes us away from the plain text of the statute, which compels us to compare these faults. These are essentially individual injuries, as we have argued, because they are claiming precisely the same damages, and given the straightforward reading of the text under 668, we believe that compels the result that the district court reached, notwithstanding the original tortfeasor arguments.
I have a question for you too. The amount of the settlements with the jet ski defendants is not part of our record, is it?
That is true.
Yeah, both of the medical providers briefs included an amount, so we should overlook that in your briefs, is that correct?
I think that would be fairest. And given that the parties essentially agree that the settlement exists, we believe that the court can treat it as somewhat of an established fact, but to the extent that there are specifics contained in either of the parties' briefs, I don't think the court would consider those.
Thank you.
Thank you all.
Mr. Koopmans, reply.
Thank you, Your Honor. And to follow up where Judge Allers kind of started, it really is just a causation issue, and I still think that there's some confusion on that part. And really, this is just but for causation that the jury will decide. And the question is going to be, but for the medical malpractice, what would the status of her leg be like? And if they hadn't committed malpractice and her leg was still almost as bad as it was, so there's only $100,000 in damage because she can't, that something, whatever that might be, then that is the damage for the medical malpractice defendants. I mean, I think they're confusing causation with comparison.
Yeah, and I'm having difficulty understanding the distinction as well, because it strikes me as a causation issue, but I think the counter argument was ignore the collision damages, the broken leg, the pain and suffering lying in the water, in agony type of thing. But the damage to the artery, I'm not even gonna try to pronounce the name of the artery, we know what we're talking about, right? The artery, they're saying, look, some of the damage could have been done by the jet ski. Obviously some of it was done by the jet ski, but in terms of how bad it got, why can't a jury compare that fault as far as that item of damage goes?
They are not going to compare the fault, but that is going to be part of causation. So it runs again. So you can imagine a hypothetical where if they would have diagnosed it and her leg would be perfect today, in which case whatever the value of her leg is, that is the damage that they have to pay. If they would have caught it immediately, her leg would be better, but it would still not be great. That means that, let's say it's then half, her leg is worth half the value. So there is
So it still comes down to a causation issue, because all you proved in that case is they only caused the 50% damage to the leg, not the 100%.
Correct, and they want to take the 50% value of the leg. They want to say, well, but you still hit by the jet ski driver. And to Don, your point, that innate feeling, like, how do you compare that? And maybe to make it more distinct, if her leg would have been perfect but for the medical malpractice, then what does the jury do to throw out a number? Who's at fault for what? These are two completely different things. And as the Supreme Court said, it's because the original tortfeasor's liability on that claim is vicarious. And you can't have liability in the same claim in Chapter 668 not apply. That is directly what Justice Waterman and our Supreme Court held in Jones.
If we were to agree with your position, do we just reject any adoption of Restatement 3rd, Section 35? Because the illustration that the defendant cited in the brief seems pretty close to what we have here with the podiatrist and the later doctor treating the patient.
That's when they all are together, and in that restatement, they are, in fact, kind of negating the original tortfeasor rule, because the original tortfeasor is only responsible for their comparative fault. And so if that's going to be done, it's going to have to be done by the Iowa Supreme Court, because so right now, the precedent is that the original tortfeasor is responsible for the entirety of it. And while that's a comment, and I'll actually sort of cited the restatement, I don't think that signals that the case has effectively been overruled.
What about the point made by the first opposing counsel here about, it was close to all the opposing counsel here, we got about 55 seconds here. The argument that if we were to adopt your position in reverse and send it back, we should just kind of, for lack of a better phrase, shut up about the comparative fault and let the chips fall where they may down the road, since you haven't moved to strike that defense.
It's an awkward posture. I mean, they effectively filed a motion that doesn't really exist, a motion to confirm comparative fault. Essentially what they filed was like a points of law, like a deck action within the case. And so this is a matter of law based on the fact, there are no facts in dispute that would change anything one way or the other. So you can decide as a matter of law that in this kind of case, based on what's in that comparative fault does not apply. If there's some brand new evidence that comes up at trial, then perhaps they can renew it.
How does the application of John, the way that the medical defendants have done in their briefing, not lead us to where they want to go?
Well, in John, you do not have an instance in which there's a special rule about professional malpractice and that they have a duty to treat this indivisible successive injury. And so you don't have the problem where the original tortfeasor or the plaintiff's negligence can't be compared. In John, you also have, they're looking at restatement sections that apply solely to products liability. And in John, it was a successive indivisible claim, and here we have divisible claims.
Can I ask a little bit about what exactly you're looking for? Let us say that you win, we agree with you. What does the remand look like? Because I'm not particularly satisfied by the suggestion we sort of just vacate the ruling and hope everything works out going forward.
The ruling would be that the Comparative Fault Act does not apply, meaning you cannot compare the original tortfeasor's fault in this medical malpractice action. And then we would go on and have the trial, and we would have to prove causation. I mean, and I don't know if that was very satisfactory, but one more thing that brought up to the point is that I don't think they appreciate that if you can have the Comparative Fault Act, the burden actually flips. We have the burden to prove causation. They almost want to make it so that they have the burden to prove that the original tortfeasor's actions were the cause and that they didn't do anything wrong. So everything is screwed up here. And I think the simple answer, that threw me for a loop about just send it back. I don't know what that means. Really, the Comparative Fault Act does not apply to this case, and that's the opinion that you should issue.
Thank you.
Thank you.
Thank you, Counsel. Thanks to all three counsel for your excellent arguments today and being willing to appear in this setting. We really appreciate that. And also the excellent briefing was very helpful to us. And we will consider Shimp versus Gibbons submitted, and we will have a written decision as quickly as the court can. And we will have a momentary recess while we switch our panels. Thank you.
All rise.